Salutations to all our future judges. In this video, we are going to see Indian Evidence Act 1872. But before going into the video, I'd like to make few requests to our viewers as well as the subscribers. Kindly do not skip the video. Watch the video from the beginning till the end. If you skip in between, you may be missing very crucial information or very crucial aspects which have been explained. Hence, watch from the beginning till the end. And next request is, please do have a notebook and a pen with you, because various questions which have been asked in Evidence Act in various exams would be mentioned or would be stated. And in addition to this, idea would be given as to how questions could be framed in a particular section. It is very important for you. So you all need to make a note of all these aspects. And in addition to this, some additional illustrations would also be given while teaching the act. Hence, you please make a note of all those additional illustrations as well. They would be of absolute help to you in understanding the particular section. And in addition to this, various ways or techniques would be taught which would help you to remember those sections, or to say some memory techniques would be given. This would be really helpful to you in remembering the sections when you go to the exam. I hope this video would be of absolute and great utility to you. Section 151. Indecent and scandalous questions. If a person is asking a question which is indecent or scandalous, or if there is an inquiry which is conducted which is indecent or scandalous, then the court may forbid such question or inquiry. However, there are some exceptions to this. If that particular question or inquiry relates to fact and issue, or relates to matters necessary to be known in order to determine whether facts in issue existed or not, in all these situations, indecent and scandalous questions can also be permitted by the court. Section 152. Questions intended to insult or annoy. If someone is asking a question only with an intention to insult the witness or annoy the witness, then in that case, court shall forbid. Please understand, in the previous section, the word may was used, but in section 152, they use the word shall. It means like the court is bound to, the court shall do. However, if the question looks proper in itself, the question may be fine, but still if it appears to the court that it is needlessly offensive in form, then in that case also the court shall forbid that particular question. Now let us move to section 153. Exclusion of evidence to contradict answers to questions testing veracity. Now try to imagine this. A witness is standing in the box and I am going and asking a question to him. And that question is asked with an intention to shake his credit by injuring his character. He also answers the question. Then in that case, no evidence can be given to contradict that witness who's standing in the box. But if he gives a false answer, he may be charged for giving false evidence. That is permissible. However, there are certain exceptions to this. Exception 1. The witness is standing in the box. I am going and asking that witness, sir, have you ever been convicted for any crime? I am asking the witness. The witness is saying, no sir, I have not been convicted of any crime. And in that case, if I have an evidence to prove his previous conviction, I can show it to the court saying that this witness is not saying the truth. He was already convicted for a crime. I am having the order copy. Please see this. I can show it to the court. That is what is stated in exception 1. Now let us move to exception 2. If I am asking a witness or witness is standing in the box, I am putting a question to the witness. or I am asking a question in such a way that the answer proves his impartiality. Let us try to imagine this particular scenario. Witness is standing in the box. I am asking him, sir, you were quite impartial to the people who are working under you. For some people you are doing good, for some people you are doing bad knowingly, and you are not treating them properly. And he says, that particular person says, or the witness says, no sir, I didn't do like that. Then in that case, he can be contradicted. It is permissible. So these two are the only exceptions to this particular section. These exceptions may be asked as a question. Now let us try to understand this particular section by way of the illustrations provided. Now, the first illustration. There is a claim against an underwriter. Let me try to explain who is an underwriter. If there is a company will have debts, loans, and it will also have assets, liabilities and assets. Everything will be there in a company. So in that case, this underwriter is a person who calculates all these things and says like the company is having so much loan, the company is having this much liability, and this is what is the worth of the company now. All these things he will write based on the documents what has been provided to him. So in that case, a claim against an underwriter is put. So a case is put against the underwriter. Let us try to understand like that. And that underwriter is saying, no, they committed a fraud. That is why I had to give a statement like this. Now, the claimant is asked. He is coming into the box. He is asked, sir, with respect to a former transaction, you had made a fraudulent claim. He says, no, I did not make any fraudulent claim. Then you are showing in evidence to the court saying that this claimant has already done a fraudulent claim, and you are showing that to the court, but that evidence is inadmissible. Simply we can understand this. A person is coming to the court and saying previous transaction is not fraud. Now you are proving that previous transaction is fraud by way of a evidence. That evidence is inadmissible. Illustration B. A witness is there in the box. He is standing in the box. I am going and asking him, sir, you were dismissed for dishonesty from your job. Is it correct? He says, no, I was not dismissed for dishonesty. Now I am showing evidence to the court that he was dismissed for dishonesty. The evidence is not admissible. Let us move to the next example, C. He says that person A is standing in the box, and he is saying that on a particular day he saw Mr. B at Lahore. Then I am asking this A whether you were staying on that day on Calcutta. He says no. No sir, I was not in Calcutta. I was in Lahore at that time. Now I am showing evidence to the court to prove that on that particular day he was at Calcutta and not at Lahore. The evidence is admissible in this case, not as contradicting on the fact. It cannot be accepted as a contradiction of fact. For that purpose, this particular evidence cannot be admitted, but this can prove that on that particular day this person was at Calcutta only. For that purpose, we can use this evidence. Let us try to simplify this example further. I am saying to the court that I was at Delhi on a particular day, but the opposite party is showing an evidence to the court that on that particular day I was at Bangalore. I say no, I was not in Bangalore, I was in Delhi only. Now the evidence which is showing that I was in Bangalore is admissible for only one purpose, to show that I was in Bangalore and not in Delhi. Only for that purpose it can be taken. But in all the above said examples, A, B, C, in all these cases, if the denial is false, then that person can be charged for giving false evidence. For that purpose, this evidence can be used. Now let us move to the next example, D. A person by name A, he comes into the witness box. I am asking this person A, sir, you had a blood feud with the family of B. There is one family, and in that a person or a character is there, his name is B. And I'm asking to A, sir, your family had a problem with the family of B, against whom you are giving evidence. Is it correct? He denies it. He says, no, no, no. Then in that case, I can contradict him on the ground that the question tends to impeach his impartiality. To simply say, if I am having a problem with one character and I am giving evidence against that character, it is quite natural that I will favor my own people rather than the person who is opposing this. Section 154. Question by party to his own witness. Now, the subsection 1 says that I can ask a question which will be asked in cross-examination to my own party. Generally, if I bring the witness, I will do the chief examination and not cross-examination. So in that case, whether I am permitted to ask questions which can be asked in cross-examination to my own party, the answer is yes, but subject to the condition, court may in its discretion permit this. Court has to give a consent to do this. Now, the second section or the second subsection is that this section will not disentitle the person so permitted. For example, I am putting a cross-examination question to my client. He is answering that question and there is some record or some evidence created by such witness. Whether I can use this or whether I can rely on this, the answer is yes. You can rely on this. It will not disentitle the person so permitted. I hope you would have liked the video. If you like the video, please do press the thumbs up button and do share the video with your friends and motivate them. If you are not subscribed the channel, please do subscribe the channel and share the channel with your friends. If you feel that I've left something in this video or you want me to change the way in explanations are given for the sections, please do let me know by way of comments. Let us join hands together and contribute for a learned society. Thank you.